Okay, welcome to our second video on jurors and the jury system. If you recall, our first video was on the selection, the disqualification, the excusal and the deferral of jurors. Well, our second video is going to be on jury vetting and then the role and process of juries. So without further ado, let's get straight to it. What's jury vetting? Well, the picture might be a little bit misleading because, of course, it has nothing to do with animals. Jury vetting is about the check-in to see whether or not a juror is suitable for jury service. And our starting point for this is Article 6 of the European Convention on Human Rights. And Article 6 says that everybody is entitled to a free and fair trial by a jury of our peers, people who are like us and who can make a decision about our guilt on the basis of the way in which we live our lives and our understanding of right and wrong and honesty and dishonesty and those sorts of key concepts. Now, the mere fact of checking a jury to see if they are suitable might seem to go against this idea that we should be tried by a jury of our peers. If we are selecting people, then we could possibly be selecting people that are like us out and putting people who are not like us in. And we have to think about the reasons for this. There are a number of sort of key causes why this might be the case. The first, of course, is to prevent corruption. And if you think about it, there are a number of key cases in which there are major gangs, big crime groups, big crime lords who are able to control and manipulate juries to have a situation in which the law is not seen to be done fairly. So one of the reasons that we vet jurors is to make sure that this doesn't happen, to prevent them trying and hearing a case for which they have a particular bias. The second reason is for reasons of national security. And by that we mean we do not want jurors sitting whose presence on a jury could affect the security of our nation. So those seems to be two very, very good reasons that don't breach Article 6, or that at least are more important in terms of making sure that the whole judicial process is fair. The third one is a little bit harder. The third one is where a government, and the abbreviation for government is GVT, the third one where a government wants a politically attractive verdict. And what do we mean by that? Well, what we're trying to do is we're trying to balance these first two, which seem to be very, very sensible reasons for jury selection, against the third, which is about governments wanting politically attractive verdicts. If a government wants to be seen to be doing its job in terms of law and order, then of course it's going to want to make sure that it gets the right verdict in cases. Knife crime is a current one that I can think about. With that, of course, governments might push to make sure that its jury system contains the right sort of people. And that would be counter to the good reason for jury vetting, if that makes any sense. All right, so the other thing that we need to think about is who does the vetting? Well, predominantly, jury vetting is a prosecution advantageous system. The prosecution has access to all sorts of government records, which means that they have control over every juror. They know much, much more about every juror than the defence will have. They'll know about criminal records. They will know about driving records. They will know almost anything that they need to about an individual. That doesn't mean to say that the defence cannot vet jurors, but it tends to only vet jurors in terms of cause, what we know as cause. And by cause we mean ineligibility, let's see if I can spell this right, ineligibility, for bias, or for disqualification. And of course the problem with all of these three is that the only way that a defence team can really know that somebody is ineligible, biased or disqualified from service is if they actually know the juror. So the prosecution can have access, they don't need to know, they have access to the data, the defence not necessarily so. So jury vetting is a problematic area in this sense. The prosecution are far stronger in terms of their ability to vet than the defence are. So a number of things to think about for us there. All right, let's look at our next area, which is the role and process of the jury. How does a jury get to where it is, and what is its main purpose? What does it do? And we're going to look at four real process areas, and then we're going to look at two roles. The first, as I've said time and time again, is that we are entitled to be tried by a system or a jury of our equals. We are be entitled to be tried by a group of people who are like us, who see the world the way that we do. And the key issue, of course, is that the jury are the arbiter of facts. The arbiter of facts. And by that, I mean that they take all of the information, all of the facts that are presented in court, and on those facts they decide whether or not the defendant is guilty or innocent. The judge, of course, is the arbiter of law. He or she is the person that decides whether or not evidence that is presented is legal, whether what the definition of manslaughter is, whether or not this is an issue of intent, whether or not things should go to the jury. He is the or she is the arbiter of law. The jury are the arbiters of fact. And we also know that generally we require a 12-0 verdict. There are 12 jurors, and we normally would require 12 of those jurors to agree, because that supports the principle of beyond all reasonable doubt. And this would be known as a unanimous verdict. However, on occasion, the judge can decide that he will accept either an 11-1 or a 10-2 verdict, and these would be known as majority verdicts. Normally, they would happen after some time when the jurors weren't making a decision. The judge might possibly send them away overnight and say, come back tomorrow and I will accept then an 11-1 or a 10-2 verdict. So that's the first area. They are arbiters of fact. The second is that they have to be free from bias. And one of the ways that we do that, if you remember from the last video, is that they are randomly selected. All right, so they are randomly selected by computer. Oh, Mr. C there. Randomly selected by computer. And that, if you think about it, providing that they are eligible, when we looked at that last time round, providing that they are eligible for jury service, and there are millions of people eligible for jury service, the computer selects them at random, a little bit like the lottery. And therefore that removes an element of bias. That removes the chance that somebody on the jury might know somebody in the defendant in court. The second area, when we've done this, is that the jurors, when they arrive, will be numbered around about 15. So 15 jurors arrive at court. And whilst they go upstairs to watch a DVD on their job, what it is that they're supposed to do, how they're supposed to behave, what their duties are, a court official will select 12. So a court official selects our final 12 from the 15. And this gives us a second level of randomness. Okay, so we've got two levels really to make sure that we maintain this unbiased nature of the jury system. The fourth of the roles is about time, the amount of time that people spend. Generally, a court case lasts about a day and a half. However, a juror is told that they should be prepared to give up 2 weeks of their time to jury service, but some juries may be sat on particular trials for 6, 7, 8 months, even longer. And a juror won't know that until after they've arrived. They won't know what case they're sitting on. And if it's a large major fraud, of course, those could take months and months and months to hear all the evidence. And once a jury is sworn in, they remain sworn in for the entire length of the case. So you might tip up at court one day, and then 6 months later you may still find yourself sitting in court listening to the evidence. Of course, the alternative to that is that you arrive in court and a day and a half later you're back at work because your job is done. So it is completely random in terms of what court case you get and how long you might have to spend in court. So if those are the four processes really at this level that we need to look at, there are two issues of role. What is it that juries do? And the first, of course, is that they assess all of the evidence. And by evidence, we mean a number of things. We mean photos. They might see photographs of the scene, CCTV, real evidence. And by real evidence, I mean things like in a stabbing case, then the knife would be real evidence. They might want to look at the knife. They might have to look at expert reports. So you might have the coroner's report. You might have scientific experts. And the third, which is the most important, is to listen to witness. Oh, look, I've spelled that wrong. To listen to witness testimony. There we go. To listen to witness testimony. That's the main job that they have to do. Most of the evidence that is presented in court will be presented by witnesses who will stand in the dock and give oral testimony. They will tell the court what they have seen or what their input to this case is. And the jurors will then have to sit and listen to that and assess all of that information for the facts, what it is that go towards proving the defendant guilty or innocent. To help them with that, they may make notes, and those notes can stay with them throughout the court, within the court. They can't take them away at night, and they certainly can't take them away at the end of the court case where they will be destroyed. So, what then happens, once all of the evidence has been finished, the next part of that process, I can't have my pen, the next part of that process is that the two legal sides sum up. So the legal sides sum up, and it's called summation. And what happens is that both the defence and the prosecution will give a summary to the jury of their case. The defence, of course, will be trying to convince the jury that their client is innocent, whilst the prosecution will be trying to convince the jury that the defendant is guilty and should be convicted. Once that is finished, the judge passes legal comment. He directs. All right, so that's something that's known as direction. And what that means is the judge will take certain areas of the law and explain those areas to the law to the jury. A good recent example, not only of the 10-2, but also of a judge direction, was in the recent Joanna Yates murder trial. And in that, the judge ended up settling for a 10-2 verdict, and at the same time spent a lot of time directing the jury on what was meant by manslaughter, what had to happen for a jury to find a verdict of manslaughter as opposed to a verdict of murder. And then what happens is that the jury go away and they deliberate. And by that, I mean that they'll sit together as a group and they will discuss the facts, they will discuss all the evidence that they've heard to come to a conclusion of guilt or innocence. They will be told by the judge what he or she will accept in terms of that deliberation, whether that's a 12-0 unanimous verdict, which is normally the case, because of course that goes to the heart of beyond all reasonable doubt, which is our standard of proof in terms of a criminal court. And if they can't do that, they will come back to court. They will tell the judge that they can't make a unanimous verdict, and normally at that point the judge will decide whether or not he or she will allow an 11-1 or a 10-2 majority verdict. And then they come back to court and they give that decision. And that's pretty much the role and process of a jury. Okay, so our next set of videos will be on the advantages and disadvantages of the lay magistracy and the juror system. So thank you very much.